Have you ever wondered what loss of consortium is in the state of Kentucky? Today we're going to cover that topic. I'm John Whatley with Stein Whatley Astorino. I have my partner Rob Astorino, and we're going to discuss this so that maybe you come away learning a little bit more about this particular claim. Loss of consortium has a statutory basis in Kentucky law, KRS 411-145. Rob, can you maybe tell us a little bit about the nature of a loss of consortium claim?
Sure. Loss consortium is a traditional legal claim where if a person is seriously injured or if they pass away due to legal fault of someone else, that either their spouse or their children can recover additional damages for the loss of, essentially the relationship with that person. In Kentucky, there's a statutory definition of what consortium is, but it's also a traditional legal definition that's existed for, centuries, that includes household services, assistance, aid, companionship, all those things that, you associate a familial relationship with. And in Kentucky, it's available currently under the law for spouses if something happens to the other spouse, or for children if something happens to their parent.
Okay. Also, this is a little bit of minutia for legal speak, but I want to discuss it maybe for lawyers that out there don't know, but also for just the general public, that these cases are derivative but separate claims. Can you maybe discuss what that means, that what is a derivative claim?
Sure. Like John said, we're kind of splitting hairs here a little bit, but it can come into play when you're dealing with insurance coverage and limits that define either a single occurrence or a single person versus a separate limit for the entire policy itself. While a loss of consortium claim is its own claim with its own damages, so the loss of consortium is separate from any pain and suffering or any economic damages suffered by any of the parties related to this injury. If you're dealing with an insurance claim, it will come out of the same line item of insurance. And so even though there are two people involved in this claim, you have to have two people for a loss consortium, insurance companies still get the benefit of a single person insurance limit when they're dealing with it. So the derivative factor, that's generally where it comes into play. You can't have a loss of consortium claim without an underlying legal injury.
Right. Well, I want to put a little flesh to that, what you talk about. So, and attorneys will probably understand that easily, or should. The average person that just heard what you said might be like, well, what's that mean? So, let's use a minimum policy in the state of Kentucky for auto. Let's say this is an auto injury, and it's $25,000, $50 for a whole occurrence, but $25,000 per person. What you are saying that is, since you have two people, you do not get the full 50, but you're going to be limited to only the 25,000 that's available to the original claim. Is that correct?
Sure, and we have a video about insurance policy limits, but yeah, it frequently comes up in motor vehicle claims where there is a limit for each person involved in the wreck, and there's also a limit for the entire wreck itself. And again, loss consortium, even though there are two people, the law in Kentucky is that because you cannot have a loss consortium claim without the underlying injury, both the loss consortium damages are applied to that single person limit, even though that may not make a lot of sense.
Yeah. So the next thing I'd like to discuss is who can bring a claim. Traditionally, it's always only been a spouse, but in recent times, case law has kind of expanded that to also include children in certain circumstances. Can maybe you dive into that?
Sure. So, Kentucky loss consortium is defined by a law that was actually passed by the state Congress. But like I said earlier, the damages of loss consortium is a legal procedure that's gone back centuries, well before our current set of laws. And traditionally, it was only available to spouses. It was the loss of relationship that a wife had from her husband's loss, or loss of relationship that a husband had from the wife's loss. About 30 years ago in the 90s, Kentucky expanded that definition and recognized that children, have a great benefit from their parents, and that the law should protect children's interests in this consortium as well. Children obviously benefit greatly from their parents beyond just the income they earn. I'm sure, any parent out there can understand and respect the value that, you add to your child's life. So the law in Kentucky does recognize that. And, if children lose a parent, or if a parent is significantly injured to the point where they can't, assume that same role, children can independently recover that line of damage.
Right. That case was the Giuliani versus Geiler case, 1997. It is an interesting case. It was brought by a 33-year-old mother of 3 children, but ultimately it was 4, that died after giving birth to her 4th child. And the facts are just a super sad situation, but essentially the physician that was involved in the case induced this woman and then left to go to a friend's dinner party, was not available by phone call to the staff. Ultimately, the staff was unprepared to deliver this child, did deliver it, and they were not able to save the mother. So this is a situation where it's just awful situation. It makes it up to the Supreme Court, and they make new law on it, and to expand that to include children. And the reasoning from the court is essentially that KRS 411-135 included parents' loss of consortium for their minor children. And the Supreme Court inferred that, well, conversely, the children, as you discussed earlier, have the same familial benefits that they get from their parents. And the Supreme Court stepped in, created or expanded this case law. The legislature has not in any way changed or talked about it, so we can kind of assume that they are in agreement with that. Otherwise, they would have.
Yeah, and even if they're not, it's the law of the land.
Yeah, correct. So it's a very interesting case, and it's good for those people that have a lost loved one, especially children that lose a parent, that rely heavily on all the resources, and not just monetary resources, but the affection of a parent every night that you come home, you put them to bed, give them their PJs, give them baths, all that sort of stuff.
And that's an important point to remember, about loss of consortium. Like John said, it's that really tragic case when children, lose their young mother, especially, under such, senseless circumstances. But the thing that you have to remember about loss of consortium is that it's not an economic claim. There are already ways to recover lost income, lost monetary value to your family, and we've talked about those in other videos. The loss of consortium is the intangible benefits of your familial relationship that you no longer have. Just like pain and suffering damages are the intangible, loss from, your own pain, your own change in life circumstances. A loss of consortium claim is the intangible loss of, all of the relationship things from family members that can't be reduced to a dollar figure.
Right. Well, we'll shift gears and maybe talk about statute of limitations, how that affects these types of cases.
And so, just statute of limitations briefly is it's a law statute that is passed by a state legislature that says after a certain period of time you can no longer file these kinds of claims. And in Kentucky, the loss of consortium claims are governed by the 1-year personal injury statute of limitations. So that can get a little bit tricky in cases of death, loss of life. there are different statute of limitations for the underlying loss of life claim versus the living relatives loss of consortium claim. And so you really need an attorney who, one, understands the difference, but doesn't forget that those are two different claims. They both need to be pursued. We'll talk a little bit about what to look for in an attorney who's going to pursue one of these claims for you. And that's the very first thing they need to remember, is that the statute of limitations is different.
Yeah. You get in trouble very quickly there. One of the other things I think is really important on these cases is, at least in Kentucky right now, there are no caps for your recovery on loss of consortium claims. In some other states there are. So we're very lucky there that if a young child loses the companionship of a parent or parents, that they're able to get the full value of that. They're not arbitrarily capped in any way. Also, there's been some changes on case law. At one point in the state that you were limited at death, but that's also been expanded by case law to include loss of consortium claims that even if the person is injured and then later dies of their injuries, your loss of consortium is going to still be viable beyond the death of the person that was injured. Sure. That's very important.
Yeah, an important thing to remember is that, a lot of attorneys, when they look at loss of consortium claim, they only consider it if someone passes away. These claims are available anytime there's a serious injury or death that affects that familial relationship. You have to be careful, just like with any claim, you don't want to overreach. Juries are going to be skeptical if you try to have a big loss of consortium claim after a minor injury that, is better recovered hospital bills, lost wages, that kind of thing. But you don't have to have a family member that passes away to have these claims. A serious injury that dramatically affects the familial relationship is still something that you can pursue one of these on. And our office has had some really good success, making these claims in the cases of
traumatic brain injuries.
Yeah, traumatic brain injuries is one that comes up a lot, as well as, injuries that change the ability to work around the house, those kind of things.
Yeah, permanent injuries that cause mobility problems, disability.
Absolutely.
Well, let's talk a little bit about that. I think that's a good segue into the next topic, which is essentially proof of evidence challenges in these types of claims.
Yeah, I would say, the biggest challenge to making a loss consortium claim is the reluctance of certain people in your jury pool to recognize them. Frequently, there's people out there that feel like, loss consortium is double dipping. We talked earlier about this being a derivative claim, and while we just explained all the ways that it was different, it was additional damages that you can't really compensate in other places. There are some people who may be in your jury pool when you go to trial who say, hey, I'm already giving you pain and suffering. I'm already compensating you for the intangible things. I'm not going to compensate you for that too. And so that's something that you have to figure out, immediately. Are you going to have resistance to that just with the people that you're dealing with? But addition, if you make a loss of consortium claim, the claim is about your relationship. So if the relationship between parent and child is not strong, if you haven't been part of your child's life, if the husband-wife relationship is on the rocks, they're going to be able to examine all that when we get into the case. So you definitely want to have an attorney that understands how not only to present that in a favorable way to a jury, because everybody has problems with family members from time to time. It doesn't mean that your relationship isn't valid, but you also need an attorney who's going to be there to inform you as a client, hey, this is what's coming. We need to be prepared for it. Don't take it personally. These are questions that get asked of everybody, and so it does. Loss of consortium claim is probably the single most personal claim that you can make in litigation. You get lots of really personal questions, and it doesn't seem like. I mean, it is your relationship with those people that you care the most about will get pried into, it will get examined, and the defense is going to have a right to do that, to see if there's any weak points there.
How would you, I guess, give us some examples of how you would go about proving these types of things as far as the relationship?
So, offering evidence at trial to establish a good loss of consortium claim can be as simple as, talking about the things that you do and you spend time with those people that you care about. You can also offer more, and I don't necessarily want to call it economic, but more, you know, tangible things that you do around the house, such as sharing housework, things like that people have lost. There are potentially other ways to recover for those as well. But anything that you can do to show a strong relationship. We've used wedding photos in certain cases. We've used pictures from the birth of children. Attending children's activities, sporting events, things like that.
Vacations.
Those are, anything that you do that you spend time with the people that you care about, and it's all the stuff that people always take for granted in these type of things until they're taken away. But we really have to drive the point home that these relationships are not to be taken for granted, and that is the most important thing you can do when you're presenting one of these claims, when you're showing the evidence, is do the work to remind everybody that these relationships are valuable and they do take work, and they're not something that just is to be taken for granted.
What's your advice to this is a two-part question.
Sure.
One, what's your advice to the person that is seeking counsel? And what is your advice to attorneys out there that might be watching this that are maybe not super familiar with personal injury, but they're trying to do a personal injury case, and the pitfalls and what to look out for?
Sure. I would say, any clients who have had a spouse or a parent or a child who's been seriously injured, seek out an attorney who goes to trial, who is familiar with loss consortium. And if you approach an attorney on behalf of a severely injured or dead loved one, and that attorney is not discussing your options with loss consortium, that may not be the right person for that case. There are a lot of attorneys, that focus on simple claims, that don't have complex injury experience, that don't always know where the line is for something like this. And like we said, you don't necessarily have to have someone who's passed away to have a loss of consortium claim. But it's good for an experienced attorney to let is this injury serious enough? And, is your family the type of family that is going to have a good loss consortium claim, both legally and factually?
Yeah.
As far as, other attorneys who may not be familiar with, injury work generally, anytime someone approaches you and says, I've had a loved one who's passed away, what should I do? Immediately you're going to want to get in touch with an attorney with strong trial background who understands these claims. And the last thing you want to do is wait and assume that you're okay because of the normal wrongful death statute of limitations, because the loss of consortium statute of limitations, they often come up in medical negligence situations. Those cases have a lot of legwork to do before you're able to even file suit. And that 1 year deadline can really creep up on you. And if you miss a loss consortium claim, sometimes those are the most valuable claims in the case. You can get yourself into trouble. So it's really important that you speak to an attorney who knows what they're doing and is able to help with these kind of things. We've handled them in the past for both clients who've unfortunately had loved ones pass away, also had loved ones be seriously injured. We've handled them successfully in all of those scenarios, and we're here as a resource for both people and attorneys if they need us on these.
The place that I think is tricky, that I think that, and this is true for some personal injury attorneys where they get hung up, is not necessarily the wrongful death claim, but it's an auto claim where there's a serious injury, and they're so focused on the serious injury that they assume, they don't think about, they know that there's a loss consortium claim for the spouse, but they just assume that it's the same statute date as the auto.
Yeah.
And we've seen it come over where for whatever reason they fired their original counsel. We get it. It's a little after the year. And we're like, well, whatever happened to the loss consortium claim? And it was just never signed up. And now that particular attorney, is potentially looking at a malpractice case for not even advising them of this particular.
Yeah, and like I said, before, I've talked about it in the wrongful death context, but yeah, Kentucky's, automobile wreck statute of limitations is generally 2 years. Loss consortium statute is 1 year. So if you're just approaching, the auto wreck, you're planning to file within that 2-year deadline, you don't recognize the loss consortium claim. If it's in between that 1 and 2 years, you can have a problem. So it's important that you always approach your case, with your eyes open and full knowledge of what you can get for your clients.
Right. All right. Well, we hope that you found this informative today. If you have any other questions, feel free to give us a call. There's also a lot of information on our website. That's steinwhatley.com. Come out and check us out. Have a wonderful day.